out later in the semester how you prove that Kentucky didn't have jurisdiction to rule in the case, and that the case shouldn't be binding, meaning the case judgment shouldn't be binding. Okay, so quick summary, just to back up before we jump into Pennoyer. In order for a court's judgment to be binding, the court must have personal and subject matter jurisdiction, so we've established that. In terms of subject matter jurisdiction, state courts are courts of general jurisdiction, as we see over there, while federal courts are courts of limited jurisdiction. Federal courts have limited jurisdiction because of Article 3 of the Constitution. Federal questions and diversity jurisdiction are the two types of subject matter jurisdiction, the two ways you can satisfy subject matter jurisdiction. In terms of personal jurisdiction, state courts are limited by the 14th Amendment, the Due Process Clause of the 14th Amendment. In terms of personal jurisdiction, federal courts are limited by the Due Process Clause of the 5th Amendment. All right, so we're all there. Okay, now we can finally get to Pennoyer. So the readings for today introduce you to the topic of personal jurisdiction with the Pennoyer versus Neff case, as you know. Why do lawyers even need to read the personal jurisdiction doctrine? If you're a plaintiff's attorney, you need to know which court can make the defendant appear and uphold whatever judgment you may or may not get. Most important, all the proof in the world of negligence and damages won't help your client if the court you choose has no authority or power to rule in that particular case. You're essentially wasting your time. As we can tell from this case, Pennoyer is super old. It's 1877, right? So why read this case? And the next one we read is 1945 International Shoe, which is a big leap from 1877, but they're still super old cases. And essentially the reason that every civil procedure student in the country reads these two cases is because they are considered the foundational cases on personal jurisdiction. Case law has progressed, as we'll see, since Pennoyer, but this is where it all began, right? So International Shoe, we'll see, starts to develop today's more complicated doctrine of personal jurisdiction, but Pennoyer is the baby. It's where it all, it's the birthplace of personal jurisdiction. So in order to truly understand the Supreme Court's current stance and law on personal jurisdiction, it's important to see how it evolved from Pennoyer to International Shoe. So the court decided Pennoyer versus Neff approximately 100 years after the country ratified the Constitution and approximately 90 years after Congress passed the first set of federal rules of civil procedure. I want you to understand, as you can glean from the case, that the court was just starting to develop their personal jurisdiction doctrine with regards to the 14th Amendment, which was ratified after the Mitchell versus Neff case. And so, although these cases were decided in the pre-industrial era, the nation's business people are starting to expand. And so what was happening is you're seeing railroads are starting to be laid, companies are starting, or corporations are starting to be formed and becoming the new business model. And so there's all of this expansion in terms of industrialization. And so prior to that, there really wasn't a need to have a personal jurisdiction doctrine because people kind of stayed within their own communities. But as the industrialization started to happen, it started to get a little more complicated where they're saying, well, I did business with this person, in New York, how do I, and they screwed me over, how do I pursue a cause of action against them? So that's why it's all part of history in terms of the need to have a personal jurisdiction doctrine. So the court's basically trying to accommodate for the changing shifts in terms of transportation and business. So Pennoyer versus Neff, attorney Rangaswamy, did I say it right? Mm-hmm. Yay, all right. So let's talk about the first lawsuit. What are the basic underlying facts of the first lawsuit? What's the dispute about, meaning Mitchell versus Neff?
So Neff hired Mitchell for legal work and never, so then Mitchell never paid his legal fees. So Mitchell then sued Neff to pay the fees, and that occurred in Oregon. And then Mitchell when he's tried to sue Neff was Neff was in California instead of Oregon, so he couldn't get, like, he was having problems trying to serve him. So instead of, like, going up to him and saying, like, you've been served, he serves him constructively by,
Publication, right?
yeah.
Okay, so hold on. All right, so perfect. So, so you're off to a great start. So we know Neff hires Mitchell, right, as an attorney about a land patent that Neff has. He says that Neff allegedly didn't pay Mitchell's fees. He gets mad, he sues. Who wins the first lawsuit which was brought in Oregon? Neff or Mitchell?
Neff. Oh, Mitchell does, and then,
Okay, so Mitchell, right?
yes.
Okay, so Mitchell, and he wins how? What type of judgment?
Because Neff failed to appear.
Excellent, and that's called a,
Is it default?
yeah, default judgment. Confidence, you got this. All right. So Mitchell gets a default judgment in state court. Basically means that Neff didn't show up. So if you have a case filed against you and you don't show up, the plaintiff wins by default, right? They assume you're not here to defend yourself. So the court proceeds on. So what is the citizenship, Attorney Healy, of the parties in the first suit? What are the citizenships? What states are they from?
Oregon and California.
Which is which?
Mitchell's from Oregon and Neff's from California.
Okay. So we know that Mitchell is a resident of Oregon, but Neff's a non-resident, right? And as Attorney Rangaswamy said, Neff was not personally served, and as you know, did not appear in court, and was actually living in California at the time. Okay, so Attorney Healy, how does Mitchell, the attorney who won the lawsuit based on the default judgment, try to collect his attorney fees?
So after the first judgment, Neff has 300 acres in Oregon, of land in Oregon. So to satisfy the judgment, he goes to the sheriff to seize his land. The sheriff then sells the land to Pennoyer. He was given a deed as evidence of the title, and the sheriff gives the proceeds to Mitchell.
Excellent. All right, so this is interesting. If you think about this, so he's like, "Hey, I got this judgment. I want my money," right? So Mitchell discovers that Neff has property in Oregon. So he has the sheriff seize the property, and you can do that, meaning if there's a debt that's owed. And here, Neff's debt to Mitchell is what he's trying to get. So to satisfy the debt Neff owes Mitchell, the sheriff in Oregon seizes and sells the land. Is anybody feeling sorry for poor Neff who doesn't know what the heck's going on? No?
Not really.
Okay, we'll see if you have some sympathy when I tell you the background or how sleazy these guys are. So you know, don't you? You shake your head? I'm not going to call on you, but...
Yeah, I mean, it's like, he didn't serve him in, like, some, like, little newspaper that, like, doesn't matter. Like, he's never gonna know you got sued. Like, that's his name.
Do you have a statement or a question?
A question, actually.
Okay, hold the question. You have a question too? Remember, you got to write your question down. Write it down. All right, moving forward. Okay, so we know that the sheriff seizes the land, sells it. Who buys the land? An unsuspecting Pennoyer. I still feel bad for Pennoyer. Pennoyer has nothing to do with all this. He goes, purchases some land, and he's totally getting screwed, in my humble opinion. So let's talk about the second lawsuit, which is the meat of the case, which is in terms of what you read today. Is this case in state or federal court, Attorney Rangaswamy?
This is in federal court, I believe.
Okay, what started the lawsuit, of the second lawsuit?
So Neff sues Pennoyer because he goes, I think years later or something, he goes back to his land and he's like, this is my land, and
Give it back, right?
Mhm.
Okay, so we know the second lawsuit started because Neff goes back to Oregon and says to Pennoyer, hey, essentially give me my land back. What are you doing on my property? So who's the plaintiff, Attorney Healy, in the second lawsuit?
Neff.
Okay, this can be somewhat confusing because he was the defendant in the first lawsuit, but you're on it. So if you're counsel, Attorney Healy, for Neff, what's going to be your argument as to why you should get your land back?
That the first case was never valid in the first place, so Pennoyer's new title is void.
Excellent. So I'll be honest with you. So the two of you are doing the best that any student has ever done in 9 years of me teaching civil procedure. Straight up. Like, you guys are I don't want to jinx you, but you're in straight rock star mode, so don't mess it up. Like, seriously, you're doing really, really well. All right, so the deed, so if you're if you're Neff, you're going to say, I want my land back. The deed that you have, Penoyer, as Attorney Healy said, is invalid. Because the default judgment in the first lawsuit is not valid because the court that issued that judgment lacked personal jurisdiction over me, Neff, at the time. So he's saying that court didn't even have jurisdiction over me, so your deed isn't even valid, Penoyer. Give me my land back. If you're representing Penoyer, Attorney Ragaswamy, the land buyer, how do you respond to Neff's argument?
He, legally bought this land. It was sold by the sheriff, so.
Yeah, seems pretty legit, right?
It would be pretty legit, yeah.
Yeah, I agree. So you're going to say, look, I have the sheriff's deed, a deed from the sheriff, not even a private owner, right? That says I have proper title to this land, despite any mistakes that occurred in that first lawsuit, not my issue. I've got a legitimate deed here that says this is my land, Penoyer, go away. Neff, go away. So the central issue in this case is whether the notice by publication was valid, right? So as to render the judgment in the state case, meaning Mitchell versus Neff, binding on the non-resident defendant. So we're trying to see if service by publication, meaning you notified a defendant about a lawsuit against them in the newspaper. And just so you know, when people do service by publication, it's in the classified section. Who still reads the classifieds? Typically you don't read the classified section unless you're looking to buy something, right? A car, something. But that's where it's listed, in that tiny little writing. And it's just to give you a little bit of context there. So then what on an intuitive basis was wrong with the process that led to the judgment in Mitchell versus Neff? Well, the obvious. For all we can tell, Neff may have never even discovered that he was being sued because he was in LA. Like, what's the likelihood that he was visiting in Oregon the day that it was, published in that newspaper? So because Neff was in California, there's probably no way for him to see the notice in that Oregon newspaper, which to me is inherently pretty stinking unfair, right? So what source of authority, Attorney Healy, justified Mitchell's attorney's method of service? Why did he even think that he could do publication, not publication, notice by publication?
There's a statute in Oregon that says that you can do that for not less than 6 weeks or something, and you have to get a receipt from the printer of that publication that says they put it in their publication basically.
Absolutely, excellent. Okay, so we know that Neff wins the second case, right? He gets his land back. Supreme Court holds that the default judgment in the initial case was invalid. So the Supreme Court said because the initial case was invalid, we're going to give Neff his land back because that court did not have personal jurisdiction in that first case. So why was the default judgment, Attorney Ragaswamy, why was the default judgment against Neff invalid?
They said that a state cannot exercise personal jurisdiction over non-residents only on the basis of property. Because he wasn't properly served, so they can't just take his property because they can't exercise personal jurisdiction over a non-resident just on the basis of property.
So how can they exercise jurisdiction over a non-resident? He has to either be served within the state, right?
Mm-hmm.
Or what's the second way?
Or they can exercise personal jurisdiction in rem, or they go after just the property.
I'll let you have that, but I'm looking for something else. So as of now, in Penoyer world, there's two ways that the court can assert personal jurisdiction. One, they can be served within the state. And what's the second way?
Is that whenever the second state, or his?
Oh no, did I jinx you too? I jinxed you. So we have brave souls that are willing to join the firm. Thank you. Go ahead.
Is it if the state in which you reside gives permission for other states to exercise jurisdiction over you?
No. but I like the effort, yes.
Is it if they voluntarily appear?
Yes, voluntary appearance. Yes, thank you, thank you. Okay, so Attorney Healy and Attorney Rangaswamy, y'all owe those two co-counsels for stepping in, because I wouldn't have done that in law school. I would have sat in my chair and said, good luck. Okay, so yes, all right. So we know that the court found the default judgment invalid because Neff was neither a citizen of that particular state nor had he been served there. The court reasoned that if a state court attempts to exercise in personam or personal jurisdiction over the defendant, that involves merely a determination of the personal liability of the defendant. He must be brought within this jurisdiction, again, by service of process within the state or voluntary appearance. So what's most important is, based on Penoria, right now there are two ways to assert personal jurisdiction over a defendant. You either serve them while they are physically within the boundaries of your state, or they voluntarily show up. Neff did neither. He wasn't served within the state of Oregon, and he obviously didn't voluntarily show up because there was a default judgment ruled against him. And he didn't know that there was even a lawsuit being filed. So that's why the court said, we're not going to hold that particular judgment valid. Now let's think outside of Penoria to today's world just for a minute. Can you imagine if this was still the extent of personal jurisdiction, how much people would get away with stuff? So you'd have to catch me in your state. So if I do a contract with somebody in Texas and I breach my contract, they either have to catch me in the state of Texas, based on Penoria's world, and serve me, or I have to voluntarily show up. Guess what? I'm going to do the contract. I'm going to get the money. I'm going to breach the contract. I'm not coming back to Texas. If so, I'm going to let you know I'm there. And I'm sure as heck not going to voluntarily show up when I know I breached the contract. So you can see how Penoria is just the start, but how when we start to read more cases, we need more rules than this. And today, especially with the internet and technology, like, I need more protection as a non-resident defendant. I need to feel comfortable doing business with people outside of my state and knowing I'm not going to get screwed if they breach their contract. Okay? So, what if Neff was a resident of Oregon? Let's change it up a little bit. And Neff was in Oregon at the time of the lawsuit. Would there be personal jurisdiction then? Yes. Yes. I see you shaking your head. Absolutely, there'd be personal jurisdiction. And Penoria would win, even if there was publication by, I keep saying publication, notice by publication. If he was a resident of Oregon, once you're a resident of that state, any judgment made by the state of Kentucky that I'm a resident of is going to be binding, because the whole idea is states have control over their boundaries and sovereignty over their citizens. If you're a state of Kentucky and you're staying in my state and my boundaries, you're going to abide by our rules of the state, good old state of Kentucky, right? Medical marijuana, what do you call it? Conventional? Commercial? No. Recreational marijuana. It's not legal here. So guess what? In Kentucky, you're in my state, you're gonna abide by my rules. Now, if you're in Colorado, you abide by Colorado's rules, right? You can smoke, right? And not get in trouble for it. So the point is, the idea is each state has control over their residents, and what judgments they make based on those residents is binding. So the whole concept of the full faith and credit clause is another state is going to have to honor, different judgments that come from different states, as long as those judgments were properly executed, as long as there's no funny business going on, as long as the state that made the judgment had proper subject matter jurisdiction, proper personal jurisdiction. And that's just keeping people from getting screwed. Okay? So we like this. This is fairness. Remember the process? We want the process to be fair. So we like personal jurisdiction. We love personal jurisdiction. All right, so what if Neff was a resident of Oregon and he happened to be in Illinois, but he was still happened to be in Oregon, not a resident of Oregon, happened to be in Oregon, he was served with process while he was there. Would the judgment be binding then? You're saying yes, why?
It seems like it falls under one of the two ways he could be served, yeah.
Which will remind us again.
They can be served within the state, or they can voluntarily appear.
Excellent. All right, so let's spend a moment talking about what the first row was, I think they were referencing, jurisdiction based on property, because that's in this case as well. So let's spend a moment talking about jurisdiction based on property. So if a piece of property lies within a state's borders, does the state have the authority to issue judgments on that piece of property? we know the answer is yes, right? If it's within the physical borders of that state does have the authority, the power to issue judgments based on that piece of property. So let's make sure we understand the three types of property-based jurisdictions. Three types of property-based jurisdictions. Okay, so essentially there's in rem jurisdiction, really two ways, but to obtain territorial jurisdiction. We'll say in rem jurisdiction, quasi in rem jurisdiction, and then I'll explain how personam jurisdiction sort of kind of works. And I've already put the PowerPoint from yesterday's class up, so if I move forward before you write what's on the slide, it's on the Blackboard site, so you can get it then. All right, so the Pennoyer case introduces three categories of territorial jurisdiction: in rem, quasi in rem, and personal jurisdiction. So we'll discuss in rem jurisdiction first. It's my favorite because it's the easiest. In rem jurisdiction is simply based on the property. Okay, it's referred as jurisdiction in rem. So jurisdiction based on the property. So under in rem jurisdiction, the court has the power to adjudicate the rights of any person in the world, but only with regard to that particular property. So essentially, in rem jurisdiction occurs when the underlying lawsuit is about the property itself. That's the key to in rem jurisdiction. The underlying lawsuit is about the property itself. So you have two people fighting over ownership of a boat, two people fighting over ownership of a parcel of land. No, it's my land. No, it actually, the borders, the border for my land starts, at mile marker 7. No, it doesn't. That's part of my land as well. So the dispute is specifically about the property. And property can be physical land, it can be a boat, it can be a car. But in rem jurisdiction, the dispute is specifically about the property. Quasi in rem jurisdiction is different. Quasi in rem has nothing to do with the property. Quasi in rem jurisdiction means I want to sue Professor McNeil in Illinois. She's not a resident of Illinois, but I live in Illinois, and I don't want to have to travel to Kentucky to get her. And I just found out she has a condo in Illinois. So I'm going to file my lawsuit against Professor McNeil in Illinois, and I'm going to attach her property at the beginning of the lawsuit to assert jurisdiction, to show the state of Illinois, even though Professor McNeil lives in Kentucky, you have jurisdiction over her because she has property within your state, within your boundaries. So can you please let me try this lawsuit here? So the catch with quasi in rem jurisdiction is if she wins, she can only get the value of my property that's going to be seized and sold by the court if I don't pay the judgment. So say I owe her $250,000, the property is only worth $80,000. That's the catch with quasi in rem. You're only going to get the value of the property, and she can't bring the lawsuit up against me again. So the most she's going to get is $80,000 when I really owe her $250,000. So that's why there's strategy in civil procedure in terms of where you file the lawsuit. It's not a smart idea for her attorney to file it in Illinois if she can't get her full judgment. So quasi in rem jurisdiction, the substance of the lawsuit has nothing to do with the property. The property is just a way of satisfying the judgment. So again, quasi in rem jurisdiction, the property has nothing to do with the lawsuit. It's just a way of satisfying the judgment. So Pennoyer, as we know, is really in rem or quasi in rem, Attorney Rangaswamy.
Sorry, can you say a question?
The Pennoyer case, is it an in rem or quasi in rem?
In her, I guess it's quasi in rem.
Why? You're right.
Because he's not trying to get the land. Pennoyer's, or I guess for Mitchell was trying to get the land in order to be paid back for the legal fees that he was supposed to get.
So the land was attached as a means of satisfying the judgment, but the dispute wasn't about the ownership of the land. Everybody got that? Okay, you're doing really well. Told you it wouldn't be so bad. So then the difference between quasi in rem and in rem jurisdiction, again, is very simple. In rem, the underlying lawsuit is about the property itself. Quasi in rem, the lawsuit is about something else, but you're attaching the property as a means of trying to establish jurisdiction in that state. Okay? Awesome. All right, so jurisdiction, in personam jurisdiction, meaning jurisdiction over the person, over me, Professor McNeil, is better. Why? Because if you get jurisdiction over me, I'm personally responsible for that debt, meaning that judgment. So whatever property I have, including my paycheck, you're going to get all your judgment because you're going to suck me dry until I fulfill my obligations for honoring that judgment. So if out of all of the three, you want in personam jurisdiction. You want me personally to be responsible, held accountable for whatever judgment might be held against me. So at the time of Pennoyer, personal jurisdiction could be found in two ways, as he stated. You're breaking the...
Is it supposed to be on a different slide?
No.
Okay.
Okay, but thank you.
Okay.
There's no more. I think that's the last one. Yeah. At the time of Pennoyer, personal jurisdiction can be found in two ways. One, personal jurisdiction over the residents, right? And two, personal jurisdiction over people physically present within the case. So that was at the time of Pennoyer. But the Pennoyer case itself says that you need personal service of process. You have to serve an individual with processes in the state or they voluntarily appear. So again, the law at the time of Pennoyer was simply states have personal jurisdiction over residents and they have personal jurisdiction over anyone physically within their boundaries. The Pennoyer court, meaning the Supreme Court case in Pennoyer, said that personal service of process within the state is an acceptable way, or if they voluntarily appear, okay? So if you're a plaintiff, what type of jurisdiction would you prefer to have over the defendant? We all know that is personal, in persona. Okay, so let's get back to the litigation before we run out of class time here. So wasn't Neff's property in the state? Meaning, yeah. So why couldn't the state exercise power over it, either Attorney Healy or Ramaswamy? So if Neff's property was in the state, why couldn't the court exercise power over it?
Because the state was, or the lawsuit was not over the property, it was over seizing monetary funds from Neff.
Attorney Healy, why
I thought it
couldn't?
was just because the underlying,
Think about process. So it's a process question. What did they do wrong in the process to where the property, the state could not assert power over that property? How does the process work if you want to do quasi and rem?
Well, he wasn't served, I guess, he constructed.
All these hands, look at these hands. You guys gotta know this. Attorney Healy.
is it because Mitchell never served Neff about the property, never attached the property to his specific case? Is it because Pennoyer brought a new case about the property against Neff?
So timing. So the property has to be attached, thank you, Attorney Healy, at the onset of the lawsuit, okay? So the property wasn't the basis for the action, and it wasn't attached until after the judgment was rendered. So remember, you can use quasi and rem jurisdiction, but it has to be attached at the time of the lawsuit to show, look, there's personal jurisdiction. You can't go after the fact, after the judgment has been rendered, and then say, oh, here's property that I found they have. So, it has to be attached at the beginning of the lawsuit, and it wasn't. So for both in rem and quasi in rem jurisdiction to apply, property has to be attached at the beginning of the case. That is a standard rule that has not changed and will probably never change. It's just out of fairness with the process. The fact also suggests in the case that perhaps at the time Mitchell sued Neff, Neff didn't actually own the Oregon property. It's not really explicit, but it sounds like he might have acquired the property after the judgment, which again is not valid. The property has to be owned at the time that the court's trying to use that as a basis for jurisdiction. So let's just have a little break here for a moment. See, it's not that bad, right? Told you. And this is the hardest case, so you guys are golden for the rest of the semester. Really, really good. You should be feeling really good right now. You should be tap dancing underneath your desk, in my humble opinion. But that's just me. All right, so why did the Supreme Court care so deeply about whether there was an attachment? Sovereignty, state sovereignty. The state can affect non-residents, so they want to make sure that states aren't overreaching their boundaries. It's very clear that personal jurisdiction stops at residents. Neff was not a resident, and boundaries. So without attachment bringing property into the district, there's no basis for jurisdiction over Neff. So again, the Supreme Court, the reason they put so much emphasis on the attachment is to preserve this notion of state sovereignty, right? Personal jurisdiction stops at residence, Neff was not a resident, and boundaries. Without attachment bringing property into the district court, there's no basis for jurisdiction. We're doing really well. All right. So one final point about Penoria in this case is, why was personal jurisdiction really important? Like, why was this such a big deal in this case, attorney, either of you? Why was it such a big deal? Personal jurisdiction. Yes.
Isn't this the case that like established the concept of like?
It did, but why was it so important in the outcome of this case? It's not a trick question, it's actually
Because the
really easy.
underlying
Yeah.
case was about personal jurisdiction.
Yeah, because why? Why did it matter?
Because Neff felt like he wasn't actually served properly, didn't know about the underlying case, so
Which affected the,
property going to Penoyer.
yes, and the,
Due process.
you're gonna throw all the baseballs out? The whole case, everything was about the validity of the judgment. If the judgment was valid, then Penoyer keeps his land. If the judgment's not valid, Penoyer doesn't get his land back. So that's why the court was, it was such a big deal. So who says you need personal jurisdiction for a valid judgment? Where does that come from? Attorney Ringaswamy.
Is it the Constitution?
Uh-huh, and where else? I said it earlier. The Constitution and specifically what portion?
The due process.
That's one. What was the other one? You remember, I put them
Oh,
up.
the full faith and credit clause.
Say it confidently.
Full faith and credit.
Yeah,
clause.
cocky with it. Like, I know this. Full faith and credit clause. All right. So we know that for a valid judgment, for personal, you need personal jurisdiction for a valid judgment based on the Constitution and the full faith and credit clause. And so, with respect to the full faith and credit clause, can't talk today, Penoyer was essentially saying that the court, the state court rendered a valid judgment in Oregon. You can't question it because of the full faith and credit clause. That was what Penoyer's argument was. And the court does agree in this case with Penoyer and says that a federal court, of course, must respect sister state judgments. But if you look at this next clause of the, which I don't have it up now, of the full faith, next section of the full faith and credit clause, it says that, again, there was still a very key underlining piece missing, which was he did not show up voluntarily, and that because of the initial judgment was not valid, the sister state did not have to honor that judgment. So what if the Oregon court had underlying jurisdiction? What if they actually had jurisdiction? Well, obviously, if jurisdiction is present, then Neff, in his federal lawsuit, couldn't question the earlier default judgment, but that was the whole issue, it just not being valid. In terms of the due process clause of the 14th Amendment, judgments over persons where personal jurisdiction is lacking does not fulfill due process requirements, because remember, you cannot deprive someone of life, liberty, or property without due process. And so asserting a judgment over a court's judgment over someone that doesn't have personal jurisdiction, meaning that court didn't have the authority of it, violates that due process clause, that fairness clause, right? The kind of dirty definition of due process is notice and opportunity to be heard. And Neff, in this case, did not receive that, right? He didn't even know the lawsuit was filed against him. So we'll talk about, again, later in the semester, the due process clause in terms of personal jurisdiction in a little more depth, but that's kind of the core to that. So I want to briefly talk about some of the human drama, because there's a lot of underlining stuff that I always find entertaining about this particular case. So Mitchell did buy the property for about $300,000, He sold it to Penoyer for 5 times that amount for $15,000. Does that seem equitable? No, that's ridiculous. So because of the holding by the Supreme Court, Penoyer lost the land for which he spent all that money. So Penoyer gets completely screwed in this process. Like, he didn't get his money back, like he lost the land, which is crazy. So who's to blame? Well, it's not Neff, right? Because he's a homesteader who by all counts was an honorable man. It's not Penoyer, who was a beloved figure in Oregon history, ironically, and went on to serve as governor of the state, Governor Penoyer. Isn't that kind of cool? Mitchell really is the bad guy in this case. So he was a Pennsylvania lawyer, and this is where it gets a little reality TV dirty-ish, who abandoned his wife, left the East Coast with a good deal of his client's money, and with his mistress, who went to Oregon. So that's how Mitchell got to Oregon. There he married his mistress without divorcing his first wife. He became a successful land lawyer in Oregon, but also a scandalous member of the legal community in Oregon. A local paper published the love letters he wrote his second wife's younger sister. Interestingly, his personal life did not keep him from serving as, guess what he ran for? Senator! Are you kidding me? Like, you published letters, love letters you wrote to your wife's younger sister? Ew. And you get to be elected United States Senator for Oregon. The good news is he was convicted of land fraud, unrelated to the Penoyer case, so it did catch up with him, and sentenced to jail, and he died while the case was on appeal. So that would be good old Penoyer. So the takeaway from Penoyer, which again will be on the class website. The court sets forth 3 basic principles of public law with respect to a state's authority to exceed its territorial limits. Those 3 things are: every state possesses exclusive jurisdiction and sovereignty over the person or property within its territory. That's a very wordy way of saying states have power or authority to assert jurisdiction over anybody physically within their territory, or that's one of their citizens. Okay, physically within their territory or one of their citizens. So you need to remember that the person has to be a citizen. If they're not a citizen of that state, they have to serve with process while they're physically within that state's boundaries. So we know, looking forward to today, even without being civil procedure experts, obviously the court has expanded that because people get served out of state all the time, right? 2, no state can exercise direct jurisdiction and authority over persons or property outside its territory. Same thing, that the notion of presence, which we'll talk about when we discuss the international shoe case. And then lastly, the Constitution, meaning 14th Amendment due process clause, 5th Amendment due process clause, and the full faith and credit clause requires not only personal jurisdiction, but also proper notice. Remember, I said due process is notice plus opportunity to be heard, and so that's where that comes in. Not given proper notice, not fair to rule a default judgment against you. So before I move on to the hypos, questions now. Questions. See? Yes.
I'm still confused about why they couldn't serve him personally to begin with. Why they, did he just abandon the fact that he had to pay anything at all?
So why they didn't just serve Neff?
Why, I don't know, I guess what I'm trying to ask is why did they think that a constructive notice would be enough?
Because of the statute. So the Oregon statute said that it was okay to serve by publication, and what the Supreme Court said is that statute violates due process. That's not a sufficient way to provide notice.
So it also, in effect, it may also kind of also invalidate that statute?
Absolutely, yeah.
Okay.
Federal always trumps state. That's a rule throughout law school. There are some exceptions, which is funny, like the whole marijuana thing. And the reason I talk about it is I'm writing an article on it because I find it kind of entertaining that federal law says marijuana is illegal, but they're allowing the states to legalize it, so there's a conflict between federal and state. So technically, federal law can enforce state law and invalidate the Colorado law, but they're looking the other way and trying to see, maybe we'll see how this goes, but it's just interesting to me. Yes?
Does it also say that service by publication could be sufficient if, if the property was brought under the control of the court, or if the person is a resident of the state?
Technically, yes, but we'll spend a whole class on notice and service of publication. It's changed since that.
Okay.
Peoria is just beginning, so I don't want you to say, oh, that's black letter law, and I don't want that ingrained in your mind, because I don't want you to put that on the exam. I'm in the back, and then yes.
In the second bullet, when you're saying they don't have direct jurisdiction over non-residents, but they still would have jurisdiction through the quasi and rem, right?
Mhm. Yeah, so it just means, that second bullet, no state can exercise direct jurisdiction authority over persons or property outside its territory unless it's via quasi in rem jurisdiction, in rem, and some other ones you'll learn about later. It's been expanded. You had a question?
With the quasi and rem jurisdiction, you said you get what the liquidated asset is worth. So, what if your damages are $250, but the property is worth $400? Do you get the full $400?
In Peoria time, no, because Dirty Mitchell got to keep that money. But in today's times, yes. So they'll take what the judgment that you've been satisfied, meaning the amount to satisfy the judgment, and they'll give you the rest of the money back.
Minus fees.
Yeah, legal fees and other things. Any more? Okay, so I'm gonna see if this projector is gonna work. Sometimes it doesn't. Hypos here. Be nice. Yeah, I should have put this down, so it's always hard to get back up. Okay. Girls out of here. Come on. Wow, I'm so sorry. Put it down.
You bring it.
Shall I break it? Is this something really easy? Okay, so to understand Penoria's general principles and its specific holding, consider the following variations. To which does Penoria give a clear answer? In each, assume that A, a resident of Minnesota, is suing B, a resident of North Dakota, in Minnesota, where B owns some land. Okay, so A serves B in North Dakota. B moves to dismiss the Minnesota action for lack of personal jurisdiction. Just take your time, and keep in mind that at the time of Penoria, personal jurisdiction could be found in one of two ways. So the first question we're going to ask is whether or not personal jurisdiction over state residents. Is B a state resident?
Yes. Wait.
No.
North Dakota.
B's a resident of North Dakota, right? So that's not gonna work. So you could say yes, dismiss for lack of personal jurisdiction, unless he decides to voluntarily go, which is different, voluntarily appear. Second, under Penoria, personal jurisdiction over persons physically present within the state, meaning served with process in the state. So whereas B served with process within the state. Doesn't really say, right? So if we say they were served with process, would the court then be able to assert personal jurisdiction over them? Please say yes. Yes. Okay. If they're not, but you see that B owns some land there, right, in Minnesota. So which types, which I know you know this, Attorney Ramaswamy, what type of territorial jurisdiction can you use since B owns land in Minnesota? Quasi and rem. And when you're gonna attach the land? I know you will never miss that again. When do you attach the land?
Whenever it's, like, that's how you're trying to, like, get assets out of the person. Or
So
at the beginning of the
At the
lawsuit.
beginning of the lawsuit. So when you file the initial pleading, you have to show this land at this address, you know, we'd like to attach this land. And so, what's important about this hypo is a couple of things. One, we see, this is what it looks like in the real world. So B is a non-resident, and A is trying to make them come to Minnesota to defend themselves. A cannot do that unless B voluntarily appears, unless B is served with process within the state of Minnesota, meaning you catch them at the airport. Or A can force Minnesota to come using quasi and rem territorial jurisdiction as long as when A filed the lawsuit, he attached the land owned by B at the beginning of that lawsuit. Now, we don't know how much money A is asking for. Hopefully it's less than the value of the property so they can get their full judgment. Okay, so let's try another one. So same as the question we just saw, except instead of appearing to object to the Minnesota court's jurisdiction, B defaults, okay? B just doesn't show up for the lawsuit, and a judgment is entered in favor of A. So A then takes that judgment to North Dakota to enforce it. B appears at the enforcement proceeding and argues that the judgment is invalid and should not be enforced. So what are your thoughts on that? Yes.
I'm a little confused. Are we assuming that A did follow proper proceedings for like quasi and rem and attach the land before filing the lawsuit?
Yep, assume everything from the first question. So we're assuming that quasi and rem, the land was properly attached.
Okay.
So then what is your answer then? Should the court invalidate that, should they enforce the judgment against B that A has? You know the answer.
Yes.
You just said it.
I want to say yes.
Yeah. Say it confidently.
Yes, yes, they should.
Yeah, and why? Because you just said it.
Because it's the quasi and rem.
Yeah, so because quasi and rem, based on the first facts, the way we said it was properly done at the beginning, attached, even though he didn't show up, too bad, too sad. You had land there, it was properly attached at the beginning of the lawsuit, you can't now challenge it. Now, if we change the facts and say there was not quasi and rem jurisdiction, he didn't show up to the lawsuit because, like Neff, he didn't know there was a lawsuit against him. He can show up at this hearing and say, I didn't even know about this. I just got a letter in the mail saying you're trying to seize my property. I didn't even know there was a lawsuit against me in Minnesota. And so please don't put a lien on my land because that court in Minnesota didn't have jurisdiction over me. So then the onus would be on the plaintiff, A, to say, no, the court did have jurisdiction, but that's kind of how it works. And so if you don't show up for a default judgment, and the person takes that judgment to a neighboring state, your state, Kentucky, to try to enforce it, I can show up at that hearing and say, that court didn't have jurisdiction over me. So, Your Honor, don't put a lien on my land. And so when I said at the first class, a lot of civil procedure is strategy, you're going to tell your client, if somebody sues you, if Jay-Z is trying to make you come to California and you're representing Ariana Grande, and you know that New York doesn't have jurisdiction over Ariana Grande, tell her don't show up. Say don't go. Because if you physically go to defend yourself, your voluntary appearance, you're asserting to that court's jurisdiction, don't show up. Don't go, Ariana, ignore it. And then when he tries to enforce a judgment in California, I'll go to court for you and tell the court that New York lacked personal jurisdiction over you. That's why you didn't show up. And no, they're not going to put a lien on your $1 million home. Now, what we'll learn later in class, which is super interesting, and I got 3 minutes, is that they do have these special appearances where I can show up, Ariana Grande, in New York and say I'm not voluntarily consenting, to New York's jurisdiction. I'm here just to establish that you don't have personal jurisdiction over me, so you can dismiss this case and leave me alone. So they do have now a little hearings you can have where I can go to New York as Ariana Grande, because Jay-Z is trying to make me come there and sue me, and say, your court doesn't have jurisdiction over me and this is why. So through the semester, what we're gonna learn is how the court begin to build the rules of civil procedure that establish how you establish personal jurisdiction, all from this Penoria case. Penoria was the start, and now we'll see there's like all these different things you consider. Because think about internet. Penoria doesn't tell us what to do about, disputes online, right? Transactions that are online. Like, how do you do that? How do I, if you're Amazon, or I bought something off Amazon and I think the product is defective, where do I sue? Yikes. Try to figure out where the company is? Like, how does that work? And what about people like McDonald's? They have multiple regional offices, right? Where do I sue? Which state? And so that's why it's really fun, because when you start spinning the different scenarios, there are a lot of different ways, there are a lot of different challenges with respect to how do you determine jurisdiction for a corporation? How do you determine jurisdiction for someone with multiple residents? Again, I'm shady because I have an Illinois license, right? I've been in Kentucky 9 years. I shouldn't have an Illinois license. Why? Because I'm so frugal and insurance double, my car insurance. I was like, screw that. That's exploitative. It's the same insurance with the same company. So I kept renewing my Illinois license because my parents lived there. That's wrong. You're supposed to change your license within 6 months. So if you're trying to sue me in Kentucky, I'm going to be like, I'm not a resident here. You're going to have to pay to go get an Illinois attorney, and I don't think you have the money to do that because your cousin who's licensed here was going to do the lawsuit against you, so you can't get me. So how do you get me? And it's true, I really have an Illinois license.
I would prove that you're employed here, that you...
So what? I'm a resident there. My home is there. I have a driver's license there. I'm a citizen of Illinois. I mean, this is 2018. People have jobs in different places, but I'm a citizen of Illinois. I'm not a citizen of Kentucky. I own no property here. I'm not a citizen here. Matter of fact, I only teach Mondays and Tuesdays. Wednesdays through Sunday, I'm in Illinois. All summer, I'm in Illinois. All holiday break, I'm in Illinois. I'm not a resident here. Go find an attorney in Illinois. You can't get me. I'm going to evade process.
Do you have property here though?
No, I have no property here.
Not even renting?
Nope. I stay with a friend. So, great job, attorney. Can we give them a round of applause for being a hard. Okay, downhill from now.